2, 1.
This Honorable Court of Appeals is now in session.
Good afternoon. I'm Judge Neil McBrayer, and on behalf of Judge Arnold Golden and Judge Karma McGee, I welcome Mr. Jacobson, Mr. Zralik to this oral argument, which we will conduct in very much the same fashion we would if we could all be together in the courtroom today. Mr. Zralik, I know that you have reserved 4 minutes for rebuttal. That request is granted and the timer will be set accordingly. Are there any preliminary matters that we need to take up before we get into the argument?
No, Your Honor.
None for the appellants.
All right. Thank you both. Ms. Lindsay, will you call the case, please?
Robert L. Baker et al. Versus Brett Eldredge et al.
Mr. Zralik.
Good afternoon, Your Honors. May it please the court, I'm Stephen Zralik of the Nashville Bar, here on behalf of the appellants and plaintiffs, Rob Baker and his company, RLB Artist Management, LLC. We ask the court to reverse summary judgment on 2 grounds. Genuine disputes of material fact exist as to 1, whether the parties agreed to modify the contract, and 2, whether defendants can prove any of their equitable defenses. The lower court treated these genuine disputes of material fact as immaterial. It departed from controlling Tennessee law on contract modification. It incorrectly held that contract modification is a question of law when it is a question of fact. It erroneously shifted the burden of equitable defenses to my clients, the plaintiffs, and it erroneously viewed the evidence in a light that favors the movements, here the defendants. My client, Rob Baker, served as the personal manager to Brett Eldredge, a country music singer. The singer paid my client and his company commissions out of 2 companies that the singer controlled, Paris, not France, and 1 O'Clock Road. From 2013 until early 2017, there was no issue in the performance of the contract. But in 2017, the singer's brother approached my client and proposed modifying the contract, once in February and again in April. My client rejected both of these offers and even countered with 2 of his own proposals. The defendants dispute this, and they insist that my client accepted the modification. Defendants also denied that my clients ever made any counters. My client testified under oath that he was waiting to hear back on his counters and never did. After the April meeting, the brother called the singer and lied to him, telling him that my client had agreed to modify the contract when he had not. And the parties vigorously dispute these facts. These are found at the record, pages 924 to 926, statements of undisputed material facts 9 through 14. Beginning in March 2017, the defendants began paying my clients modified commissions retroactively to January 2017. Fast forward to September 2018, and the singer fired my clients. When the defendants refused to pay the full amounts owed under the contract, my client sued the singer and his 2 companies for breach of contract and asserted an alternative claim of unjust enrichment.
So did that occur right after the termination, or did your clients permit the artists here to continue to pay throughout the sunset provision at the lower rate?
It was after the sunset expired. Yes, Your Honor.
So, I mean, what grabs me about this particular case is it seems like to me at the termination point, if your client is under the mistaken impression that this is just an underpay and it'll be trued up, that's going to be the time that you would object and say, oh, and by the way, you need to do the catch-up payments, but that did not happen here.
Well, respectfully, Your Honor, the parties had a 22-month history in the past in the relationship. This is undisputed, where my client had to wait a full 22 months to be paid his very first commissions once the contract began. So The 17-month period fell within that 22-month scope, and my client made counters, and my client at every step of the way expected the singer to do the right thing and to make up for it. And so once that did not occur, and he reached out and tried to negotiate with the singer's attorney, once that did not occur and it became clear that the singer was going to maintain lower commissions the entire 17-month period and sunset period, my client sued within the 6-year statute of limitations for a breach of contract.
Is our analysis here any different because your client is a lawyer?
Well, that's a great question of fact for a jury. A jury should be able to determine whether or not, these are all modification questions under Baldwin, are always questions of fact for the finder of fact. That is black letter law in Tennessee. And so a jury can determine whether or not my client was sophisticated enough that it matters, but it was premature, respectfully, for this to be decided as a matter of law by a court at summary judgment.
Part of your argument here is that the law of modification of contract is different than just contracting generally. How so?
I think that the defendants interlap contract formation cases with contract modification cases. We understand contracts formation cases, they deal with, can a contract be found as a matter of law when there are undisputed facts, even though there's no written contract? Yes, those are the formation cases. The modification cases, there's a separate line of cases in Tennessee that follow the Baldaraci, ENA, Thompson, and those have their own laws and rules. And it's that modification cannot happen unilaterally, that where that mutual assent must be found, and it is a question of fact, not a question of law, and that where there are disputes of fact or an ambiguous course of dealing between the parties, that no modification can be found as a matter of law.
And
so,
how is this course of dealing ambiguous here?
Well, the course of dealing is ambiguous because my client twice opposed the modification, once in February and again in April, and offered his own counters. The lower court disregarded the rejections and disregarded the 22-month gap earlier in the relationship where the singer did not pay commissions. The lower court looked solely from April 2017 forward, and so the lower court picked and chose what portions of the course of dealing it wanted to look at, and Tennessee law dictates that you've got to look at the entire course of dealing between the parties. The decision below, the lower court acknowledged that there were disputed facts, the most critical one being whether or not my clients rejected the proposed modification. But the lower court concluded this disputed fact was immaterial. This is not immaterial. It's the most important disputed fact in the case. As I said, the court artificially limited its examination to the course of dealing after April 2017, and it also improperly shifted the burden of equitable defenses to the plaintiffs. Under Tennessee law, quote, whether a contract has been modified by the parties is a question of fact for the trier of fact. That's Baldwin. This is especially true where there are genuine disputes of material fact. And offerees have no duty to even respond to an unsolicited offer to modify. That's the ENA case at page 7. Baldaraci instructs that contract modification cannot arise from an ambiguous course of dealing between the parties. And this is important. Where lower courts have granted summary judgment to a defendant, such as in this case, in contract modification cases, this court has consistently reversed where the record contains evidence, like ours does, that the offeree opposed modification. And I want to direct the court to the published decision of Hill versus Goodwin, that's 722 Southwest 2nd at 671, and Glanton versus Shelby Insurance Company, 1996 Westlaw 82678. The only cases in which Tennessee courts have found an existing contract to be modified have two factors distinguishable from our case. One, they were decided after trial or after an evidentiary hearing, such as Baldwin and Basford. And two, those cases had no evidence in the record of the offeree opposing the modification like our case does. I'd like to just shift to counts 3, 4, and 5. Counts 3 and 4, my clients asserted inducement of contract claims against the brother, and count 5 seeks an accounting. If the court agrees with us and reverses dismissal of count 1, we ask the court to also reverse summary judgment on these remaining claims, since their dismissal was hinged solely on dismissal of count 1. And on count 2, unjust enrichment, we brought that claim against the singer and his companies as an alternative to the breach of contract claim, to the extent the jury concludes any of the singer's companies were not parties to the underlying contract, even though those are the ones that paid my clients from 2013 forward. We understand there can be no unjust enrichment where there is a valid contract, but respectfully, it's premature to throw out this claim before a jury, the fact finder, has an opportunity to consider whether the companies were parties to the contract. For all these reasons and those set forward in our briefs, we urge the court to reverse the grant of summary judgment to defendants on all counts. Thank you.
Thank you, Mr. Zralik. Is there any other questions from the panel?
No.
All right, seeing none, we'll hear from Mr. Jacobson.
Thank you, Your Honor. May I proceed?
Yes, please.
Good afternoon. May it please the court. I'm John Jacobson of the Nashville Bar on behalf of the defendants, appellees, Bryce and Brett Eldredge, and their affiliated entities. I want to address, before I start my argument, I want to address a question that the court already asked about the termination and the timing of the filing of this lawsuit. And in fact, the evidence is, in our view, that there was no question about what the parties' intentions were with regard to this contract. This is found, this exhibit that I'm referring to is record number 555. It's an email from the plaintiff, Mr. Baker, to Brett Eldredge, dated September 25th, 2018. This goes to the court's question about whether or not Mr. Baker filed this lawsuit immediately after he was terminated. It was the month of September 2018 when Mr. Brett Eldredge finally terminated the management relationship. And in response to that, in this email at record 555, Mr. Baker doesn't say anything about being underpaid under the contract. In fact, he says, I've been asking about the sunset part of our agreement and I'm getting crickets. He does not mention anywhere in this email, Your Honors, anything about this fact that he had allegedly been underpaid for the preceding 17 or 18 months. And to suggest now that the plaintiff, Mr. Baker, disputed or objected to those terms contradicts the record. There was not any ambiguity with regard to the course of conduct after the parties met in early 2017. Mr. Bryce Eldredge forwarded an email on March 14th, 2017, in which he set out the terms of this new agreement. The parties acted consistent with that agreement for the next 17 months, and Mr. Baker never complained. And to his credit, he acknowledged in the record that he never complained about how much he was paid. The parties, in short, following extensive briefing, the parties on cross motions for summary judgment and arguments of counsel at summary judgment, Chancellor Lyle entered a well-reasoned, thorough opinion and granted summary judgment in the defendant's favor as to all claims. And as our briefs make clear, the trial court's ruling was appropriate. The record establishes, frankly, that Robert Baker manifested his agreement to the terms of the 2017 contract through both his actions and words from April of 2017 through April of 2020. Now, the record establishes that the plaintiff, in fact, did accept the terms of the 2017 contract, never complained about those, received every month. The record established every month he and his bookkeeper, Paula Walls, received a detailed commission statement that laid out the calculation of the commissions that were payable to him. And he accepted those payments every month. The payments.
So not only were there commission statements sent every month, but there was also an ACH or direct deposit every month?
Yes, Your Honor. Thank you. I was just getting ready to say that we made ACH deposits every month, consistent with those commission statements that detailed how the commissions were calculated. The statements, the record reflected, were sent to both Mr. Baker and to his bookkeeper, Paula Walls. There was never a question about, there may have been some random loose end questions about the timing of certain payments that Brett Eldredge had received, but there were never any questions or disputes about the calculations or any suggestion that Mr. Baker thought he was supposed to have been paid under the 2013 agreement, the handshake agreement that they had reached in 2013, as opposed to the written agreement that Mr. Bryce Eldredge sent to him on March 14th of 2017. And so those commission statements and the ACH payments reflected that Mr. Baker and the Eldredges recognized that the 2017 contract controlled, and that's what the parties had accepted as the contract that governed their relationship. I'd like to address the relationship between Brett Eldredge and Mr. Baker. It's instructive to some of the issues that the appellant raises on appeal, including the suggestion that the passage of time between when Mr. Baker was told about the 2017 agreement and when he expected that he would receive a catch-up payment, he now says, that's somehow consistent with the earlier part of their relationship. As the record reflects, Brett Eldredge met Mr. Baker shortly after Brett moved to Nashville. Brett was a struggling musician here, trying to make a name in the country music business. Mr. Baker was a lawyer. I do believe, Your Honors, that the fact that Mr. Baker was a lawyer is a fact that matters in this case. The record showed that there were times when he was meticulously detailed in connection with the records that he kept and the descriptions that he made of certain events in connection with Mr. Brett Eldredge's career. Initially, Mr. Baker acted as Brett Eldredge's lawyer. That relationship evolved. In 2011, Mr. Baker started managing Mr. Brett Eldredge's career. He was working with a company called Violator Nashville when that happened. By 2013, Mr. Baker and Brett Eldredge decided that Mr. Baker should assume all management responsibilities for Brett Eldredge's career. And they ended up meeting, they actually their lawyers exchanged written drafts of a management agreement that ultimately was never signed. The record reflects that Brett Eldredge understood from his time when he was a lawyer client of Mr. Baker's, that Mr. Baker encouraged him never to have a written management agreement, but rather handshake management agreements. The two of them met outside the Dollar General on 8th Avenue, reached a handshake agreement where Brett Eldredge was going to pay Mr. Baker 15% of his entertainment income without publishing included. And publishing will be a material fact here in a moment when I talk about the 2017 agreement. The two of them had a handshake deal that was memorialized with an email that Mr. Baker sent only to Brett Eldredge the following day. Mr. Baker did not copy Mr. Eldredge's lawyer on that email, but they acted as if that agreement was the binding contract between the two of them from 2013 until early 2017. Now, the record also reflected that Brett Eldredge, like most recording artists, had several team members. Like most recording artists, they have a business manager, and that was at one point a gentleman named Dwight Wiles. Ultimately, defendant Appellee Bryce Eldredge, Brett's brother, became his business manager. Brett Eldredge also had a lawyer, David Crow, who represented him, and he had a booking agent who was responsible for booking his performances. In 2016, Brett was communicating with his brother, who at this point was his business manager, about budgeting for the upcoming year 2017. And the record shows that Bryce Eldredge, as business manager, was concerned that there were pressures on the income that Brett Eldredge was going to receive in that year. It looked as if he would work harder, make more money, or earn more money, but actually bring less home if there weren't adjustments made to some of the team members' commission structure. The record reflects, Your Honors, that all of the commission team members, including Bryce Eldredge as business manager, the booking agent, and ultimately Rob Baker as the artist manager, had their percentages renegotiated. So Bryce Eldredge approached Mr. Baker initially in early 2017. And I neglected to address the point I wanted to make about the passage of time and what the appellants allege was the early failure of Brett Eldredge to pay Mr. Baker commissions. What the record shows on that front, Your Honors, is that artists typically early in their career don't generate enough revenue to where they can pay commissions actively in accordance with their agreements with those commission team members, the manager, the business manager, and the booking agent. And the record reflects that in that instance, typically those artists will defer commissions. They'll delay paying those until they are able to. And in fact, what this record reflects ultimately is Brett was able to pay all of those commissions to Mr. Baker sometime in 2013. So he was so caught up, so to speak.
Well, was that deferral formalized in some way where Mr. Baker wrote and said, don't worry about paying commissions right now? I mean, how do we know that the course of dealing between these two particular parties, or a jury might find the course of dealing these two particular parties, is that not to raise issue about pay until a later date?
That's a good question, Your Honor. There's nothing written in the record that I'm familiar with that reflects that they had an agreement on deferral of commissions, but the testimony is clear among the parties, at least among Brett and Bryce Eldredge, that they made clear to Mr. Baker that there was a deferral of those commissions. And it wasn't just Mr. Baker. It was the booking agent who was also paid a percentage of revenue generated in connection with performances. And it was the business manager, Dwight Wiles, who received a 5% commission on Mr. Eldredge's earnings then, that also had his commissions deferred. So we believe it's a red herring to suggest that the deferral of the commissions early in Brett Eldredge's career somehow relates to a reasonableness with regard to not raising any issue with regard to the performance of the parties under this 2017 contract. So in early 2017, the record reflects that Bryce Eldredge met with Mr. Baker and talked to him about these pressures that Brett Eldredge was facing and for the coming year, and suggested that Mr. Baker needed to accept renegotiation of his commission for the upcoming year. Mr. Eldredge made a proposal that Mr. Baker said he rejected in February. Mr. Brett Eldredge returned, spoke with his brother. The record reflects after speaking with his brother, he then generated the email that I referenced earlier, the March 14th, 2017 email that Mr. Brett Eldredge sent to Mr. Baker. It's record number 532. This email of March 14th, 2017 reflects, Rob, please find attached a simple one-pager outlining a commission structure, and that commission structure is attached. It's record number 533. It lays out what the new commissions for Mr. Baker were going to be going forward. And it's very clear. And I mentioned earlier that this issue of publishing was going to play a factor here. And the reason that this matters, Your Honors, is in the new agreement, in the 2017 agreement, there is a component for songwriting and publishing. 5% net operating income, and parenthetically excluding any catalog sale. So songwriting and publishing commission on those was added by Brett Eldredge to his commission deal with Mr. Baker in early 2017. That had not been a component of their earlier agreement. So for each of those monthly commission statements that I described earlier with the ACHs that Bryce Eldredge forwarded on behalf of Brett Eldredge, it included a payment of 5% commission for songwriting and publishing. And Mr. Baker
Was the songwriting and publishing component part of the written proposal as well, or was this brand new?
The songwriting and publishing was brand new. It was not part of their 2013 agreement.
Well, I mean, about the 2017 exchange of agreements, contracts, was that part of that proposed deal as well?
Yes, sir. It is at record 533, the one pager that Bryce Eldredge forwarded attached to his March 14th, 2017 email. The songwriting and publishing is a component of that. And the record reflects that the parties from that day forward acted in accordance with the terms of this agreement. So every month from that point through September of 2018, Brett Eldredge paid and Mr. Baker accepted 5% net operating income associated with songwriting and publishing, which were amounts that he was not entitled to receive under the 2013 agreement.
So I just want to make sure I'm perfectly clear, though. When Bryce Eldredge sent a written agreement in 2017, January and March, I think, of 2017, those written agreements included as one of their terms this royalty component that ultimately was functioned or paid later in the relationship.
The only written agreement that Mr. Eldredge sent, yes, sir, included that
Okay.
commissions. Yes, sir. And those were paid through the termination of the agreement.
Is there any other questions from the panel? All right, seeing none, Mr. Drolick will hear from you on rebuttal.
Thank you, Your Honor.
Yes, Your Honor. Let me begin by just reiterating that under Tennessee law, it's black letter law that parties cannot unilaterally modify a contract as Bryce Eldredge did here. The one-page memo that he sent my client was never countersigned. There's no evidence of that. And the defendants, the court is instructed by precedent to examine the entire course of conduct between the parties. That includes the 22-month period. To answer your question, Judge McBrayer, I'm not aware of any writing between the parties in which my client said, I understand there's a delay. There was a delay. My client, it's in the record and it's in our briefs. My client had to drain his 401k account to keep his family afloat during those first 22 months. And these are all questions of credibility that the defendant has aptly pointed out for a jury to decide, the fact finder to decide. The defendants have attempted to make it seem that my client made no complaints as to how much he was paid. He disagreed twice, and this is under oath in his deposition. Once in February and again in April, he offered counters. He expected, based on that 22-month course of dealing history between the parties, that Brett Eldredge would get it right, and he didn't. Opposing counsel pointed to an email that my client sent at record entry 555 after the termination of the contract, asking about the sunset part of the agreement. With all due respect, that email is vague. It doesn't say he's asking about the existence or payment in general, or if he's asking about what percentage would be paid. And that fact, which is unclear, is something for a jury to decide, and a jury could conclude that the plaintiff was asking exactly about what percentage would be paid. We are not aware of a single case in Tennessee that did what the lower court did here and found a contract to have been modified at the summary judgment stage. The only ones that have reached that conclusion have been after evidentiary hearings or trial, where there is no evidence in the record of opposition to modification. The Baldwin case, there's legal argument about opposition, but that's distinct from evidence. Judge McBrayer, you asked about publishing revenue, and I want to address that. There was a publishing line item that was paid for as part of the modification. But as we state in our briefs, the aggregate, and there's no dispute here, the aggregate amount of pay to my clients went down. And that's why my client offered the counters of ways to tinker with how do we keep the compensation the same. Back to the sophistication. Respectfully, it doesn't matter whether my client was sophisticated or not. The jury can consider that. But the case law says if a party opposes modification, modification doesn't occur. It doesn't matter if that party's sophisticated or unsophisticated. And accepted versus received. Yes, my client received modified compensation, but just like the plaintiff in Baldaraci, these were not checks that said payment in full. My client did not actively endorse these. These were paid automatically to his bank account. We respectfully ask the court to reverse summary judgment on all counts to the defendants. Thank you.
Thanks, counsel, for both sides. The case is submitted. Ms. Lindsay, will you recess court, please?
This Honorable Court of Appeals is in recess until 3 p.m.
Counsel, good to see you both. You can disconnect now.
Thank you, Your Honor.
Bye.
Take care.